Hey, my single parents. Hey, everyone. I'm Aishah McCoy. I am an attorney and the owner of the law office of Aishah McCoy. And today I'm here to give you some basic information on how to protect your assets as well as your loved ones after divorce. Now, the end of a marriage can bring about a whirlwind of feelings. And as a single mother, and after speaking with so many of my clients, I can say that many newly single parents feel this newfound sense of freedom and this ability to take control over their lives. But just note that this is also a time of uncertainty for so many people with the impending election, as well as the COVID-19 pandemic. And not to mention, you're having to plan for a life that you had not considered in years previous. Now, all these things considered, it's important to take control of what you can. So the best way to think about this is a great opportunity to sit down and think about the things that matter to you the most. How do you want to protect yourself? How do you want to protect your children? How are you going to protect the things that you own and want to pass down someday? Just know that these are all decisions that we can control. Now, through the use of wills and healthcare directives, as well as trusts, they can all work in concert to protect you and your loved ones in these times of uncertainty. Today, I'm going to go through the top tools that estate planning attorneys use to protect newly single parents and newly formed families. Now, the first document that I would like to highlight is the will. This is an incredibly important legal document. It functions similarly to a set of instructions that are passed down to your executor on how you want to dispose of the things that you owned. The executor is a person, persons, or an entity that you appoint through your will to follow these sets of instructions. If you have minor children, it's especially important to have a testamentary trust included in your will. The testamentary trust takes effect once you pass away, and a trustee is a person or entities that is appointed in that contingent trust. And that trustee is responsible for making distributions from your estate for the care, comfort, maintenance, and support of your children or your minor loved ones. And you can decide really what age you wish for that trust to terminate and for that entire amount to be released to your beneficiaries, usually your children. And many of our clients typically choose to terminate the trust once their children either reach the age of 18 or once they graduate from college to ensure that their tuition and associated expenses are paid for. But this can also be adjusted just according to whatever your wishes and desires are. Another important tool to incorporate within that will is a declaration of guardianship of minor child. Now, there are several negative repercussions to not having a last will and testament. Now, without a will, the state government can decide who may act as your children's guardian. And a will provides and ensures that the instructions regarding the care of your minor children are followed until they reach the age of adulthood. Furthermore, without a will, your hard-earned belongings, your cars, your bank accounts, house, and other assets may be distributed in a way that actually runs contrary to what your actual wishes are. So in order to ensure that your estate is handled according to your preferences, a will is absolutely essential. Now, aside from a last will and testament, there are also some healthcare documents that you should highly consider incorporating into your estate plan. One of the most important tools is called a statutory durable power of attorney. A statutory durable power of attorney is a document that's designed to appoint a person or persons to manage your financial affairs and your business affairs in case you are mentally or physically unable to do so. And this document is important if you receive Social Security benefits, if you need to open and close bank accounts, if you receive Medicare or Medicaid. And if you own real property, stocks, bonds, file a tax return, this document is the best way of ensuring that a trusted person that you appoint will take care of these matters. Now, aside from the statutory durable power of attorney, it's especially important to have a medical power of attorney in place. A medical power of attorney functions similarly to a statutory durable power of attorney, but you are appointing an agent to make medical decisions on your behalf just in case you are incapacitated, meaning you're mentally or physically incapable of making these medical decisions. And this document can take effect either once it's executed or once your doctor certifies you as being incapacitated. You can actually have it either way. Now, the last document that I feel is especially important, aside from the statutory durable power of attorney and the medical power of attorney, is the physician's directive, otherwise known as a living will. Now, a living will or physician's directive advises your treating physician whether or not you want to sustain or discontinue life-sustaining treatments in case you happen to be suffering from a condition from which you are not expected to recover. The best way to put it, although it's a bit macabre, is whether or not you wish to pull the plug if you're in a vegetative state. That's really the best description of how this sort of instrument works. So now that I have covered the basic estate planning tools that you need to protect you and your assets as well as your loved ones, I highly recommend that you speak with a licensed estate planning attorney that can explain the importance of having a will as well as these healthcare directives in place. Thanks, single parents. Again, I'm Aishah McCoy. I am an attorney and the owner of the law office of Aishah McCoy. And thank you for tuning in today.